Boo. I'm Mike Steger. I'm a copyright and trademark attorney. It's Halloween, and I am here to tell you a spooky tale about copyright terminations and Friday the 13th. The Second Circuit Court of Appeals in New York recently issued an opinion in a case called Horror Inc. versus Miller. This case involved the screenwriter Victor Miller, who wrote the screenplay for the horror film Friday the 13th in 1979. The film came out in 1980. And about 5 years ago, Miller decided to use a provision in the Copyright Act that allows authors of copyrighted works to terminate their grant of copyright and take back their rights in their original work. Now, this termination right only applies if the author did not provide the copyrighted work as an employee or as part of a work made for hire. And Miller said he was going to exercise these rights. Horror Inc., which now owns the rights to the Friday the 13th original screenplay and characters, sued Miller, said, no, you can't exercise these rights because you were the employee of the production company back in 1979. Well, what did the appeals court say? The appeals court said, no, Horror, you lose the case. Miller was allowed to exercise his termination rights because he was the actual author and he was an independent contractor. He was not an employee. And in doing so, it evaluated a couple factors. There are up to 11 factors that courts will look at for whether an author was an employee. And in this case, the court found that Miller had substantial creative control over the actual screenplay. He did not receive employee benefits. So for benefit purposes, the production company did not treat him as an employee. He only worked for 2 months. He was not a regular employee under any sense. And very importantly, the production company did not treat him as an employee for tax purposes, just gave him lump sum payments and gave him a 1099. Now, the arguments from the production company were that he was a member of the Writers Guild. He had signed off on the Writers Guild and he got Writers Guild benefits. But the court made it clear that those are just general benefits that are provided to members of the guild. That doesn't mean that he was an employee of the company. So the lessons for this are, if you are anybody who's hiring someone to provide copyrighted work, you need to actually treat them as an employee if you want to own the work for all time. You can't just say someone's an employee if you don't actually treat them as such. I'm Mike Steger. I'm a copyright and trademark attorney. If you have any questions about copyright or trademark issues or copyright terminations, give me a call. Don't end up starring in your own horror film of Nightmare on Copyright Street.